A heated argument over legal proceedings has left the entire Madlanga Commission in serious chaos this morning, but Justice Madlanga eventually heard what shocked him, and he couldn't react further. Advocate for Mr. Carrim argues for in-camera testimony at the commission. My client started receiving death threats, he told Justice Madlanga. The question is, who are those threatening him, and why? He fearlessly called the names of 4 bigwigs in South Africa that are after his life, and revealed the dangerous secret he has and ready to spill at the commission. Mzansi, hear the story from the horse's mouth, and please don't forget to hit the like button and subscribe for more updates.
Carrim's appearance at the commission is concerned. That would not release Mr. Carrim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected, offer him an modicum of protection where he says, I'm being surveilled and I'm threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Carrim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to, or at least part of it boils down to what I said, which is that he does not want the public to know that he will testify.
Yes, but that's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said says exactly what I say.
No,
of the various permutations you gave, part of it says exactly what I say.
I accept that, but
Yes.
we also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes, which the public at large would not know about. So it's not as though Mr. Carrim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's to, the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Carrim accepts he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me there, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this a preliminary concern now,
No,
Chair?
but no.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you,
yes,
Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Carrim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising
Yes.
in the context of that submission.
I accept that, yes.
How will the Commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Carrim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And
content
I'm
of
not
the
suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. As you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to... The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah. Oh, sorry.
Sorry, Chair, what I was going to say to you is that we obviously have no difficulty with whatever accommodation has to be made to facilitate the fair trial rights of any other witness who may be impacted by my client. But what we know, and that's foreshadowed with all due respect in Rules 4.2 and 4.3 of the Commission's rules. But what we know in practice from cases like Bryden and Helen Suzman Foundation in particular, which in your previous capacity, Chair, you would be very well familiar with. There are particular circumstances where the disclosure of evidence in a particular context is subjected to a confidentiality regime that appropriately balances the interests in the evidence coming to the court, or in this case, the
Before today's witness takes the stand, we have an interlocutory application that has been brought by Mr. SULIMAN Carrim, and it's for his evidence to be provided in camera. And Mr. Premid will address the Commission on that application. And I believe there's a preliminary issue that Mr. Premid would also like to raise with the Commissioners, if we could begin there. Thank you.
I also have a preliminary issue I wish to raise with your preliminary issues, but perhaps let's hear your preliminary.
Thank you, Chair, and for the indulgence of going ahead of you. My learned friend is correct. This is an application that my client's main evidence be given in camera. My concern at the moment is that even though the directive says that it will be given in an open session at the college, as we are here today, My concern is that if the in-camera application is argued in front of all and sundry, and I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in the way that we are physically here, but that it would still be determined in camera pending whatever outcome is to be made, as opposed to how we had asked for the reasons canvassed in the in-camera application, that it be done virtually or at a different venue and so on. And so I just have to register my concern with all due respect that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or a live television proceeding that goes out. And may I just say this, I can understand that if the Commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in where the very request for that proceeding itself is to be in camera. Otherwise, it would be, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premhead. Mr. Premhead, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Carrim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered nugatory. I just don't follow it.
I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the client on what he says in the affidavits is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does not, or rather does, undermine the very purpose of the in-camera, which was to protect that disclosure for, when he comes back to the Commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted, and that he's still giving evidence with the effect that the threats are going to materialize again, with all respect, because effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Carrim, wants the public to be under the impression that he will not be testifying, or what exactly
no,
is the point?
that's
what then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made. And if it was granted, then the public knows that Mr. Carrim ought to have testified on the 9th and the 10th. That might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these things were in camera, on the 9th and 10th, if the Commission is with me and grants the in-camera substance, then whoever is threatening Mr. Carrim and the public at large would have to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be.
On that, given what he has set out in the papers.
And that's why I started by clarifying, by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Carrim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Carrim specific matters. And so the Commission might in and of itself have its own Chinese wall laws that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Carrim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Carrim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Carrim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes? My question.
It is a yes, but okay. I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, you know, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the Commission to the public?
Does it involve breaches of confidentiality?
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Pramido, what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the Commission, it does not include a complaint that the Commission has disclosed what he asked to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified.
That's
not what you are complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
But Mr. Carrim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is
that.
actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Carrim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I continue?
Intervened twice, my colleague was still asking you. Yes, please go on, Mr.
May I
Premier.
respond to you, and then Commissioner Baloy, subject